On behalf of Brinks Hofer Gilson and Leon, hello and welcome to today's virtual panel discussion entitled Patent Reform: What Should You Be Doing Now? Part 2. I am pleased to be joined by today's presenters, Alan Baum and Ryan Marshall. Alan Baum, the managing shareholder of the firm's Research Triangle Park office in North Carolina, is chair of the Chemical Practice Group. He was named one of the world's leading patent and technology licensing lawyers and leading intellectual property strategists by Intellectual Asset Management magazine, and has been recognized by Best Lawyers in America for intellectual property and biotechnology for 7 years in a row. Ryan Marshall, a shareholder at the firm, is a member of the Chemical, International Patent, and Patent Prosecution Practice Groups. He was named Mountain State's Super Lawyer Rising Star for 3 years in a row and recognized as one of the Utah Legal Elite for 2 years in a row by Utah Business Magazine. We believe today's discussion will provide you with practical guidance on the upcoming changes stemming from the passage of the America Invents Act. This virtual panel offers 1 hour of CLE credit in Illinois. We are happy to apply for CLE in other states at your request. Please note the window below the video that states CLE tracking. There will be random check-in points during the discussion where you will be asked to enter basic information into the window provided to prove your attendance. After today's program, your certificate of attendance will be sent within 10 business days. We welcome your questions. Submit questions throughout the program via the chat window on the right-hand side of the screen. Biographies of our panelists and today's presentation can be found in the top right of your screen in the section entitled Bios and More. Click there to download them at any time during the program. And now, today's presentation, Patent Reform: What Should You Be Doing Now? Part 2.
Hi, I'm Alan Baum. I'm joined by Ryan Marshall. Thank you for joining us. In a previous episode of this series, we discussed a number of things, including inter-parties re-examination, the change of standard, virtual and false marking, prioritized examination, and removal of punishment for failure to comply with best mode. On March 16, 2013, there are some additional implementations, including derivation proceedings and conversion to a first-to-file system. We won't be speaking about any of this today because it was previously covered. This seminar will attempt to answer what should you be doing in preparation for September 16, 2012. All of these changes that come into place on September 16, 2012 are addressed in the following order. Ryan will cover the inventor's oath and declaration practice changes, as well as pre-issuance submissions of information by third parties. He'll also cover supplemental examination, and then I'll finish with inter-parties review and post-grant review. I'll turn it over to Ryan.
Thanks very much, Alan. Welcome, everyone. I'd like to begin our presentation today by discussing how the American Invents Act significantly alters U.S. patent practice in broadening who can file for patent applications. Historically, only inventors were permitted to file patent applications. But beginning in September, patent applications may be filed by persons to whom the inventor has assigned or is under an obligation to assign the invention, or by a person who otherwise shows sufficient proprietary interest in the matter. Thus, companies or purchasers of patent rights can file patent applications without the inventors participating in the initial filing under these provisions. However, such an applicant must be represented by a registered patent attorney or agent. The new statute and implementing rules will require an executed oath or declaration by each inventor unless an exception applies. So, even though an applicant can file without the inventor's participation at the outset, it will still be necessary for an inventor's oath or declaration to be filed at some point during examination. The following exceptions apply where an inventor's oath or declaration may be omitted, and these are traditional exceptions that have existed for some time, including if the inventor is deceased, if the inventor is legally incapacitated or refuses to execute an oath or declaration, or simply cannot be found after diligent effort. Where an exception applies, an applicant can file a substitute statement in lieu of the inventor's oath or declaration. Submission of the executed oath or declaration or a substitute statement can be postponed up until a notice of allowability. So that's another procedural change, that applicants can provide these at some point before the issue fee becomes due. However, if that delayed submission is something that one wants to take advantage of, it is necessary to identify the inventorship information in an application data sheet, or ADS, at the time of the initial filing or within the time period the Patent Office sets for responding to a notice to file missing parts. The ADS that's filed, or application data sheet, must list the legal name of the inventor, a mailing and residence address for each inventor, and unlike the prior rules, citizenship of the inventor is no longer necessary. The USPTO is seeking to promulgate some rules that would set a charge or a fee for filing a delayed executed oath or declaration after a first action on the merits by the Patent Office. And they are also seeking to impose a patent term adjustment penalty for delayed declarations as well. So that's something that still will unfold. Now, the content of an oath or declaration has been changed, and the following three things must be included in that declaration: a statement that the application was made or was authorized to be made by the affiant or declarant. Second, the individuals themselves must aver that they believe they are the original inventors of the claimed invention. And third, an acknowledgement that any willful false statement is punishable by fine or imprisonment of not more than 5 years or both. Previously, the rules required that an inventor must also state that he or she has reviewed and understands the contents of the application and is aware of a duty to disclose prior art that may be material to patentability. The new rules don't require this statement in the declaration. However, the new rules require that before someone can execute such a declaration, that they still be able to state that they've reviewed and understand the contents and are aware of their duty to disclose. Procedures for changing inventorship have also been changed by these new rules, and they put a greater emphasis on the use of an application data sheet at the time of filing. Inventorship correction is, for example, in a non-provisional application, requires three things. One, an application data sheet listing the correct inventors, a processing fee specified by the rules, and an executed inventor's oath or declaration for any newly added inventors. So there are some tips and strategies, things that you'll want to think about as this date approaches and you have to change your oath and declaration practice. For example, companies can now file patent applications provided there is ownership of the invention. In this regard, it's very important for employment, consulting, or other forms of agreement that govern who owns intellectual property, that those be executed prior to the development of the invention, and that they have clear statements as to who will own the rights to the invention that's developed. If an assignment is used in, let me back up, one other provision that changes in the code allows applicants to combine assignments and inventor's declaration so that there's one document that the inventor has to sign, both conveying the ownership interest to the patent owner, as well as making the declaration statements. If that form is to be used, it's important that any assignment document be sure to include those statements required by the statute and rules. Also, keep in mind that taking advantage of this new option when filing 371 actions or national stage applications from patent cooperation treaty applications can result in a patent term adjustment loss if you file the inventor's oath or declaration late. Before paying an issue fee, applicants are also required to verify the real party in interest, the owner, that has not changed. And if there has been a change, an update must be provided to the Patent and Trademark Office. And even if you did nothing else, one thing you must do that's different from what you're used to doing is you must use a new inventor's oath or declaration document beginning September 16th, 2012. The Patent Office does have an example of a form that you can use if you're interested on their website. Now, turning our attention to another topic, the pre-issuance submissions that can be made by third parties. This is also a procedure that's new under the American Invents Act and that takes effect in September. The pre-issuance submission is a method in which third parties can contribute information during patent examination under 35 U.S.C. 122. Submissions are expected to improve patent quality because it's anticipated that the prior art made available to an examiner will be more appropriate and more on point, because third parties have an interest in diminishing the breadth of claim scope. Now, there are two existing procedures that will be done away with as of September 16th, and those include third-party submissions under Section 1.99 and prior public use proceedings under Section 1.292 of the Code. A third proceeding will remain available, and that is third-party protests. Those can be made at any time during patent application pendency, as well as in post-grant practices, which I will address and Alan will address later. The submissions can only be made to applications and not in post-issuance proceedings. So again, protests are available in post-grant proceedings, but pre-issuance submissions are only available in pending applications. The pre-issuance submissions can only list and identify publications such as patents, published patent applications, or other printed publications. But again, it's only for identifying publications. Evidence affecting patentability, which is not in the form of a publication, can still be presented by way of a protest or in a post-grant review. The new rules also lengthen the period in which submissions may be made, but they must be made prior to a notice of allowance, and generally that provision is included because the Patent Office doesn't want a submission made if they provide a first action allowance of the claims. Or the submission can be made by the later of either 6 months after publication of the application, which would usually be about 24 months, or the later of a first action rejecting any claims. Now, again, the reason for this rule is to provide the examiner the most relevant art prior to any action on the merits. So, who can file a pre-issuance submission? Well, an agent can act in behalf of an unnamed party. So someone can submit something anonymously through a registered patent agent or attorney. Anyone not under a duty to disclose material information can submit information. However, if you're a patent applicant for the application, if you're the owner, if you're an inventor, pre-issuance submissions are inappropriate. And there are special requirements if parties making pre-issuance submissions have privity of contract with one another. And you'll want to check the rules to make sure that you can still supply a pre-issuance submission in that situation. A fee may apply to a pre-issuance submission. The Patent Office contemplates that if a third party is providing a first and only submission of 3 or fewer references, no fee is required. So the really good prior art should be able to work its way in without fees. However, any submission that provides more than 3 and up to 10 references requires payment of a $180 fee. An additional $180 fee will apply to any group of 10 references or fraction thereof in excess of the original 10 references that can be supplied. Now, the following file requirements also must be met. The submission must include a list of documents being submitted, and that list must contain bibliographic information required under Section 1.290E. The submission must also include a concise description of the relevance of each item listed. However, argument is prohibited. A legible copy of each non-U.S. patent document must be included. U.S. patent documents don't have to be included. An English language translation of any non-English language reference must be included, and a statement must be included that by the submitter that the submission complies with both the statute and the rule. Let me also just address what that concise statement may be. It's a narrative description or a claim chart comparable to what third parties request for ex parte reexamination. So if you're familiar with that practice, that type of submission is appropriate. Patent applicants will also be informed that a submission was made if they participate in the USPTO's e-office action program, and there is no requirement that the third party provide notice or serve a copy of the pre-issuance submission on the applicant. Now, if a third party improperly submits the information, the information will not be entered into the record, and there will be no refund for an improperly submitted pre-issuance submission. Submissions can be made by paper or over the web, but paper submissions run a greater risk of being rejected, and facsimile submissions are unavailable. To avoid and minimize the potential for third-party submissions, consider the following strategies. Again, this is if you don't want pre-issuance submissions. You can file a request for non-publication if you're not going to seek your patent application outside the United States. You can delay identification of the assignee of record until the application has been published. Also, you can seek prioritized examination or patent prosecution highway proceedings to facilitate rapid patent allowance before the application is ever published. Now, keep in mind that pre-issuance submissions may ultimately strengthen any allowed claims because the references were considered during examination. So, you may want to have those pre-issuance submissions in the record to buttress and support the validity of your claims. Now, if you want to affect the scope of claims of another's patent portfolio as a third party, consider these strategies. Identify your competitors and their active inventors soon and monitor their published applications. Remember, the timing of a first office action or notice of allowance is uncertain. And typically, since patent applications are published 18 months after their earliest priority claim, and a first office action on the merits typically occurs within 23 months of the application's filing, you will have a limited 6 to 8 month window in which you can rely on being able to file a pre-issuance submission. So be prompt in your submissions. Also, review the U.S. Patent and Trademark Office's assignments database to see if there are applications that are published that had not identified corporate owners. Now, the other thing you may want to keep in mind is you may want to reserve those pre-issuance submissions for challenging the patent later in litigation or in post-issuance proceedings. Now that examination's over, there are a few more tips I'll leave on this next slide for your review. You can submit them anonymously. But I'd like to turn our attention to supplemental examination. Now that a patent's been granted, a request for supplemental examination can be sought to consider, reconsider, or correct information believed to be relevant to an already issued patent. And this proceeding, not available before, but now beginning in September of 2012, allows patent owners to expunge potential inequitable conduct. It can also be used to trigger review of issued claims over newly discovered art, events, or information. It is available to any granted patent during the period in which that patent is enforceable. That period includes the 20 years of term, any adjusted or extended term, plus a period of 6 years after term is expired. Supplemental examination is intended to reduce and simplify litigation issues through one of two phases of review. Now, it's not characterized as a phase of review in the rules, but this is the way I understand it, and I think would be appropriate to view it. The first phase is initiated when the patent owner files a complete and compliant request for supplemental examination. The U.S. Patent and Trademark Office will issue a certificate of supplemental examination whether the request presents a substantial new question of patentability based on the information provided in the request. If the certificate that issues indicates that at least one such question is raised by the request, the procedure advances to a second stage, which is ex parte re-examination. So supplemental examination really is in this period of time in which the office considers whether there is a substantial new question of patentability. If there's not, then the supplemental examination ends. If there is, supplemental examination ends and ex parte re-examination begins. There is no limit to the number of requests that can be filed for a patent. A request for supplemental examination requires the following, and this is where the number of requests comes in. One can only list and provide copies of no more than 12 informational items to be reviewed. Once you've provided 12 informational items, if you want additional items to be considered, they must be submitted in a second request. A copy of the patent and identification of each claim for which supplemental examination is sought must also be included in the request. A separate explanation of the relevance and manner of applying the item of information to each claim for which review is sought must be included. And finally, a summary of any relevant portions of any submitted document other than the request itself that is more than 50 pages in length must also be included with the formal request. A request for supplemental examination also requires that the identification of the patent owner of the entire right, title, and interest must be submitted. And if there are more than one owner, all owners must participate in the request. And if any other post-patent proceeding is underway, whether it has concluded or is concurrent to the supplemental examination, that must be identified to the Patent Office. Now, the more controversial provision of this procedure is the cost. The initial cost for filing a request is $5,140. And you, at the time of filing the request, must pay for the supplemental or the re-examination proceeding, which is another more than $16,000. Now, if the request is deemed not to raise any issue of substantial issue of patentability, then the supplemental examination or the re-examination fee can be refunded. Any document that is more than 20 to 50 pages also requires a $170 fee, and there's a $280 fee for each document that has an additional 50 pages. So the longer the documents are, the more the fees will add up as well. Now, the PTO has a 3-month period in which to issue its electronic certificate that will be considered an attachment to the patent, stating whether or not the request raises any substantial issue of patentability. And again, if it does, then ex parte re-examination will commence. Also keep in mind that it's prohibited to have any interviews during supplemental exam, but during the re-examination process, you can have interviews with the examiner. And the ex parte re-examination that's triggered from supplemental examination is different as summarized on this slide. You can't file amendments until the claims have been acted on in a first office action, and you can't file a statement under Section 304 of the code as you usually can under ex parte re-examination. And also the documents that are available under this proceeding are more expansive than in regular ex parte re-examination. So let me just review a few tips, and then I'll turn the time over to Alan. If you anticipate litigating a patent and know about some vulnerabilities, you may want to consider supplemental examination as a way to reduce the potential issues and set up successful summary judgment motions. If you're a small or micro entity, the fee schedule that will come out in 2013 will probably reduce the fees for supplemental examination. So if you're one of those entities, you may want to hold off on seeking supplemental examination to make it more cost effective. Always keep in mind that you can file continuation applications to maintain pendency of an application and perhaps address these issues, and that might be a more cost effective way to proceed. And always also recognize that any information that is cumulative to information already considered won't prompt or shouldn't prompt a substantial new question. And you should carefully choose the information that you identify to avoid filing the more expensive supplemental examination in multiple requests. So with that, I'll turn the time over to Alan, who'll review the other post-issuance proceedings that are now available or take effect in September.
Thank you, Ryan. The timing of this webinar is good in that the final rules were just issued for all these provisions on August 14th. So during the last 2 weeks, we've learned a lot about how the Patent Office is going to proceed with inter-parties review, post-grant review, transitional period for business methods, as well as the trial rules. And the trial rules are very illuminating because they spell out how these mini litigations before the Patent Office are going to occur. I'm going to go quickly through some of these slides because these issues were addressed in an earlier episode, and they address the difference between inter-parties and post-grant review. I think a key thing to remember is that only prior art patents and printed publications are available under post-grant, under inter-parties review. Post-grant review is much broader in terms of its validity considerations. And it's also important to remember that the estoppel attaches once you've initiated one of these proceedings. You can no longer rely on that art that should have been raised in subsequent proceedings before the Patent Office, U.S. District Court, or the ITC. The fees for these exercises are $27,000 and $35,000 respectively. So there is significant cost. Those are just the Patent Office expenses. And another key difference between the two here is that inter partes review is going to start next month on any patents issued before, on, or after September 16th, 2012. So it's available for all issued patents. Whereas post-grant review is not really going to come into play for some time because patents will not be eligible for post-grant review unless they issued from applications filed after March 16th, 2013. The exception to that is business methods, and we'll touch briefly about that in a few minutes. A few other points to keep in mind. These are conducted before the Patent Trial and Appeal Board. You have 1 year in most instances to final decision once the trial's been initiated, and the proceeding is terminated if the parties settle. You can keep settlement agreements confidential. There's a route of appeal that only goes to the Federal Circuit. There's no option to go to district court, collect more evidence, and then go to the Federal Circuit. You must identify the real party in interest, and there is potential for intervening rights coming out of both of these procedures. So a few things to consider when you're thinking about, do I want to, as a potential defendant, or seek out a declaratory judgment of patent invalidity, or do I want to go back to in court, or do I want to go back to the Patent Office and ask for inter-party review or post-grant review? Well, the good news is for IPR and PGR, there's no DJ jurisdiction requirements. You don't have to wait for a threat of infringement. The cost is also substantially different. Litigations are often run into the millions. IPR and PGR will likely be in the hundreds of thousands, with PGR being more expensive because of the breadth of issues at hand. The amount of discovery you'll be able to obtain in each proceeding is vastly different. In district court, we're all aware of the extensive, almost unbridled discovery that a defendant can obtain. That will be very different from what you'll see in front of the Patent Office. You will get substantial discovery in terms of the breadth of issues in a post-grant review. In IPR, because all you're looking at is prior art patents and publications, you're going to be looking at less discovery. The grounds for invalidity vary, as I mentioned. You also have this estoppel issue to think about. Another important difference is you have a lower burden in front of the Patent Office by preponderance of the evidence in terms of what you have to show to establish invalidity versus district court litigation, which requires clear and convincing evidence. Another difference, the patent owner can amend an IPR and PGR, whereas you can't do that in court. This may be an advantage to the patent owner, but as a potential challenger, you have to realize that it's possible an amended claim still covering your product or proposed product could ultimately issue from the office. Speed is a major consideration. These IPR and PGR proceedings are going to happen fast. Once the determination has been made to proceed to a trial, which is the initial decision from the appeal board, and we'll go through that in a minute, you're looking at, in almost all instances, 1 year before a final decision. The other thing to keep in mind is that IPR and PGR, as opposed to district court litigation, you're separating the issues of validity and infringement. If you're a challenger that's in the process of developing a product, this can be a huge advantage because the patent owner doesn't have any idea what your product looks like when they're presenting a claim construction or arguing against yours. And one other thing to keep in mind, if you have a product on the market and you're thinking about instituting one of these procedures, will the knee-jerk reaction of the patent owner be to file an infringement suit? You may not want that to occur. Then again, there's always a possibility that the infringement litigation has stayed pending the outcome of the IPR or PGR. So here's some tips. Wait 3 months and a day before filing your request for post-grant review. The reason for this is that there's a provision that provides a district court can't stay proceedings in the district court pending the outcome of PGR where the patent owner sues within the first 3 months. So I think it's advantageous to wait and preclude that possibility from occurring. The other is the estoppel effects associated with IPR and PGR are likely to be different. Because in an IPR, all you're allowed to do is challenge under 102 or 103, you're not going to be precluded in all likelihood from challenging validity on 112 or 101. So if all you have is good prior art in the form of a printed publication or patent, you're probably better off waiting for IPR so that you can raise these other issues without the estoppel. There's this transitional period for financial business method patents, and I'm not going to say much about this other than in the last several weeks. The Patent Office told us what a business method is, and it is something other than a technological invention, but includes what you see up on the screen. They did identify, they provided some examples, and an example of a business method is a method for verifying a credit card transaction, whereas a novel, non-obvious credit card reading machine for verifying a credit card transaction would fall in the category of technological inventions and not fall within this transitional procedure. So how is this procedure going to work? When you're deciding whether you want to go back to the office or try to litigate in court, I think these factors in terms of how it's going to work and what you'll be able to do and won't be able to do are key to making that decision. The graphic that you see up on the board is something provided by the Patent Office attached to the final rules in the package for the trial manual, and it basically lays out the way these things are going to unfold. I note that the time change that is demonstrated in this graphic was changed by the Patent Office, but it's not reflected in the final rules. It's actually 3 months after the petition is filed. The patent owner has an opportunity to file a preliminary response. Then the board will take 3 months to render a decision. If you're able to reach any agreement on mandatory disclosures and a scheduling order, or mandatory disclosures, you're supposed to submit at that point, and the board will provide a scheduling order along with the decision. After that, the patent owner has 4 months to take some discovery and prepare its opposition papers. The patent owner will be able to file a response along with a motion to amend the claims if desired. And the way this whole procedure is supposed to work, we're supposed to narrow the issues as things go forward, and then the petitioner, the challenger, will have a 2-month period for discovery of things like declarations and experts provided by the patent owner. That is followed by a patent owner reply to opposition and amendment. Then you can request an oral hearing. There will be a period for observations as well as motions to exclude evidence, and then this will proceed to a final written decision. Again, the time between decision on the petition, which is the institution of the trial, through final decision is 12 months. Now, trial under IPR and post-grant review is very different from what we think about happening in court. There's no jury, there's no live presentation of witnesses or testimony. It's much more of a Federal Circuit style type hearing. Again, the entire period after the decision on petition is referred to as the trial. So the petitioner has the advantage, like an ITC action or any other action where one side has the opportunity to prepare and the other side has no idea what's going on. The petitioner has that advantage. The challenger has that advantage. You don't want to give that up. Gather all your evidence, line up your experts, have everything ready to rock and roll once you file. If your petition is approved, you know exactly how your case is going to unfold. Things to think about from a patent owner standpoint, if you are, from a petitioner standpoint, before we move over to the patent owner, things you want to think about for discovery are declarations filed during prosecution. What didn't they submit? If they gathered data, was it all submitted to the Patent Office? Data not included in the specification. Well, was there other data that wasn't included? Prior non-published public uses under post-grant review only, there may be more information in the hands of the patent owner or some third party that show what exactly was publicly used. Also, try to anticipate the patent owner's arguments and identify any claim constructions favorable to your non-infringement position. Now, moving on to the strategy of the patent owner, well, sometimes you know these things are coming and you can do these things ahead of time. Other times they're a surprise, but what you definitely want to do is make sure you get your expert witnesses on board as soon as possible. They may be inventors, they may be others. You want to make sure whatever positions you're taking in that preliminary opposition, which can't include expert testimony, you want to make sure your experts are comfortable with whatever you put in that initial document, so you want them on board early. You want to think about mechanisms for maximizing the estoppel effect of the proceeding. So for example, in discovery, you may want to provide something that you think won't hurt you if you think it'll provide for a broader estoppel later on in court. And the other side, the challenger would have a hard time in court saying that they were denied an opportunity to present evidence because of some discovery issue. So the trial rules, how are these going to work? The petition, it all starts with the petition. You have to identify the real party in interest, any related matters, counsel. You have to have a registered patent attorney as your primary counsel. Backup counsel can be, for example, experienced litigators with familiarity of the case. You have to provide service information, grounds for standing. In other words, is this particular defendant barred? Is the timing of the filing proper? Which claims are being challenged, the statutory grounds of invalidity, what your claim construction is, how the construed claim is unpatentable. You really think about a claim chart. That's one of the possibilities mentioned in the rules. It's a succinct way to present your case. You have to identify the exhibits that you rely on, as well as the specific location of material you're relying on, and provide an explanation of the relevance, as well as any supporting declarations and affidavits. And a take-home message here is get your evidence in early, your expert declarations, your affidavits. It's going to be very difficult as the procedure narrows the issues to try to bring in new stuff later on, new information. Other things that are required, if you rely as the challenger or in subsequent filings after trials initiated as the patent owner on tests or data, you have to provide a fair amount of information. Why was the test being used? How's the test being performed and the data generated? How do you determine a value? What are the calculations? How's it regarded in the art? Is this a well-accepted test? Be careful about referring to things as the gold standard, because if later on it turns out the gold standard test didn't meet what you're propounding or you're saying it should provide, you're going to have some issues. Any other information necessary for the board to evaluate? Who conducted the test? When were they conducted? What instruments perhaps were used? Those sorts of things. Get it right the first time. We then have the preliminary response filed by the patent owner, and it may seem unfair, but the patent owner, as I said before, is not allowed to provide any testimony, and this includes affidavits and declarations, and no claim amendments are permitted. Examples of responses identified in the final rules include that the petitioner is barred, references are not prior art, there's a material limitation lacking in the art, an improper claim construction, or that the patent covers ineligible subject matter. The rules also say the patent owner may elect not to respond. I think that'll happen in probably 10% or less of cases, but there's no requirement to respond. And there's also always the possibility of submitting a public disclaimer of claims that you believe are problematic based on the new art or whatever that's been cited in the challenge. We'll then have a decision on the petition from the board. It'll include a claim-by-claim analysis, and the goal of the board is to try to narrow the issues and have trial move forward on some or all of the claims depending on the particular circumstances, but they really are going to try to narrow the issues, and that's the way the entire procedure is sort of set up, is to narrow things down as time goes on. The board may refuse to grant a trial in the case where the same or substantially same prior art or arguments were previously presented by the office, and they can also decline if you're seeking to challenge hundreds of claims. They are very concerned about some of the patents out there that have many claims and the burden that this would place on the office. When the petition is denied, expect no more than a brief written explanation. And upon institution of a trial, the scheduling order is granted. This will be followed by a telephone conference to address scheduling and other matters, including likely motions that each party will file. After the decision, the patent owner now has an opportunity to file a full response along with a motion to amend the claims. It could include a whole bunch of things, declarations, argument. It could include the results of discovery that it has enjoyed over the previous 4 months. And again, the patent owner should be ready to go with discovery immediately once the trial has been initiated. There's no reason to wait. 4 months will go very quickly, and you want everything you can get that the challenger may have produced in the process of preparing its challenge. Now, privilege applies, and we'll get into that as well. One important thing to keep in mind is that you want to provide any amendments you want to make as the patent owner at this particular time when you file your response. It's hard to make amendments afterwards, even when you do have, even when you have good reasons, the board may decide not to permit it if you're too far into the process, because maybe the challenger has responded and taken some depositions based on your broader claim set. Now you're coming back and narrowing them. So decide what you want to do early on, stick to it. As I said early on, alternate claim sets are permissible, and auxiliary requests for Europeans on the line are permitted. You want to avoid creating intervening rights where possible. Consider alternative claim sets, as I just mentioned. Include all declarations and affidavits, data, information, etc., to make sure you can get it in. Holding stuff back and thinking you're going to get it in later is not a good idea. There is then an opportunity for the petitioner to reply and oppose any claim amendments that the patent owner wants to make. There's some additional discovery available based on the patent owner opposition. The patent owner can then reply to the opposition. Again, the issues become narrower and narrower because the patent owner can only reply to what was in the immediate paper proceeding coming from the challenger. And then you're off to oral hearing. In most instances, it does have to be requested. And ultimately, you'll have a final written decision from the board. Again, it's only appealable to the Federal Circuit. Let's talk about discovery. There are some mandatory initial disclosures. You have two options here. The first one is names and addresses and copies of documents you intend to rely on, sort of like the Federal Rules of Civil Procedure. The second option, if the parties agree to it, provides more information, specifically references things like information relating to non-published public disclosure, as well as secondary considerations on the next slide. These are things that the court or that the board has decided should be exchanged routinely. Some caveats on discovery from the final rules. The Patent Office makes it clear that unlike in proceedings under the Federal Rules of Civil Procedure, the burden of justifying discovery in board proceedings would lie with the party seeking discovery rather than the party trying to avoid it, as we have with the federal rules. There are also several statements in the final rules that make it clear that conservative grants of discovery are what are expected. There are several mentions of the fact that Congress made it clear this was to be a less expensive, less complicated proceeding. And I think that's what you're going to see from the office in terms of the extent of discovery. Now, they don't come out with any bright line rules in terms of what's discoverable and what's not, and I'll get to that in a minute. The other thing said is that the types of discovery available under the Federal Rules of Civil Procedure can be sought by the parties in an IPR or PGR. And so that means interrogatories, depositions, requests for admissions, documents, limited email discovery. I believe it was 5 custodians and 5 search terms total for each. And attorney-client privilege will apply. Interestingly, there is no provision in the rules for how to deal with disputes around privilege. What about privilege logs? Is there going to be in-camera inspection when there's a dispute? These are all things that we'll have to see what the office does with. There are, I expect that the office will have many more discovery disputes than they're used to seeing in any of the contested proceedings they've dealt with to date, as well as interferences, and it should be interesting. 2 types of discovery other than mandatory disclosures. There's what the office calls routine discovery and then additional discovery. The difference is routine discovery, you don't have to obtain pre-authorization from the board. For anything beyond routine discovery, you have to get permission from the board before you can go forward and request it. So the few things that you're able to get by routine discovery without permission include any exhibits cited in testimony, cross-examination of opponents' declarants, depositions, inconsistent information, expert declarations. They give a couple of examples. So if you have the challenger files a declaration that says that the examples in the patent are inoperable, you have a right as the patent owner to any information that shows that, well, the examples are operable. Maybe they got conflicting test results and only provided the good stuff to the office. You deserve to get the other stuff. With regard to unexpected results, as the challenger, if there are documents in the possession of the patent owner that show the unexpected results alleged during prosecution or during the proceeding are not in fact unexpected, or perhaps worked sometimes and didn't work other times. You have the right to get that information. Now, what if you want additional discovery? Anything else? Let's say there's a third party out there who might have interesting information about a public use. Well, you have a few opportunities to try to get that. You need to explain why you need the information, and you have to schedule a conference call and get permission before you proceed. There's no bright line in terms of what you're allowed to get and what you're not allowed to get. So what's going to happen here? I think these board members are going to be dealing with a lot of requests until everyone understands what the general bounds of this are. There really are no hard and fast rules in the final rules at all. So from an impact strategy standpoint, how's this going to play out? What should you do? Well, if you want it or you think you can get it, you ought to ask for it. You ought to have good reasons why you think you need it, but you ought to ask for it. The worst that'll happen, I think, is the board will say no. If they do say no, this helps you establish a record that you were denied discovery, and it may help you limit the estoppel in court, because later on you can argue, if you end up in district court, that you should not be estopped because you were denied discovery on a vital issue. Now, discovery and post-grant review is limited specifically by statute to evidence directly related to factual assertions advanced by either party in the proceeding. And so I think you're going to see more limited discovery, although the issues you can look at are broader in inter-party review. You're going to see you may see narrower grants in PGR. At least there's the basis for arguing that, depending on which side of it you're on. Let's move on. There's also a provision for compelled discovery. You can compel a party to provide testimony, documents and things, and it is clear in the comments attached to the final, or the comments on the final rules, that this provision would apply to third parties as well. So I think we're going to see third party discovery. You will have subpoena power as a party in one of these proceedings. Various petitions and motions are provided for. You have to have permission for just about every motion, and I list a whole bunch of them there. You have to have permission ahead of time. That's the way the Patent Office handles interferences and other contested proceedings, and it's worked, and they're going to stick with it. They think it helps reduce the matters that ultimately end up requiring a lot of attention from the parties and the judges. A few comments on testimony. All direct testimony has to be presented in writing. You're not going to be putting on live witnesses for direct. Anything else is by deposition or oral examination. I think most of the time these are going to be recorded transcripts. Occasionally you'll have a live deposition when a witness's credibility is an issue. You'll have live testimony before a board member. The federal rules of evidence apply. What does that mean? That means when the evidence is submitted, whether it's in paper form or it's in written form, you have to make an objection at that time. Same objections you'd make under the federal rules of evidence. You also have to follow it up with a motion to exclude before the final decision, actually before oral hearing, to make sure that the evidence you think should be excluded because it's improper is in fact excluded from the record. Settlement. These things are settlable. The settlements may remain confidential. There's a provision that does provide access upon a showing a good cause, and it being unclear, it's unclear what exactly good cause will require in this instance. So you have to assume that someone from the government or another party could see the settlement. The good news is if you do settle one of these things before a final judgment, the estoppel doesn't apply. So something to keep in mind. And also the patent owner is precluded from doing anything that's adverse, if you will, to the decision that's made. So for example, the patent owner can't obtain a patent that is not patently distinct from a canceled claim. So there should be some finality to these actions. In summary, Ryan mentioned it before, it's really important to monitor what the competition is doing. He was talking about published patent applications. It's also really important to monitor those flag pending applications and watch and see what's issuing. Post-grant review is a very different opportunity to challenge a patent than inter partes review. And if you miss it in that first 9 months, you're not going to have the same kind of chance to conduct a challenge before the office instead of during court. And so you want to take advantage of that. IPR is also an effective or attractive option under certain circumstances. The estoppel is narrower, and you need to remember that the kind of discovery and the extent of discovery you're going to get is much more limited because the issues at hand are much more limited. And with that, we'll open it up to questions.
Thanks very much, Alan. I'm looking over the screen to see if there are any questions that were submitted, and if you have an opportunity and want to submit a question to us about the items we've covered in today's presentation, feel free to do that at this time. And while those are coming in, I have one question that I thought I'd ask you, Alan, about the opportunity to amend the claims while one of these proceedings is taking place. You mentioned something about auxiliary requests that are applicable under European practice. Could you describe what those are?
Sure. So when you read the final rules, it talks about a replacement set of claims. And the examples they give seem to indicate that all you can do is either cancel a claim or cancel it and replace it. And one of the comments that came back was that the office should provide for auxiliary sets or alternate sets of claims so that the claim set that was allowed alongside it can be presented another claim set if the board should decide an issue in a particular way. And it's very common practice in Europe. I think it's helpful because it allows you, instead of sort of committing to one thing or another, it allows you to sort of gauge the reaction of the board and see how things develop over time before you commit yourself to accepting narrower claims. Now, you'll be able to read the tea leaves from the initial written decision of the board in deciding to institute the trial, but it's just an early indication of how the board's feeling. You need to remember the board has not had the benefit of any expert testimony or declarations from the patent owner or anything else, so it's kind of hard that early in the proceeding to say, yeah, I think we should definitely limit this claim and accept something narrower, unless you've got an anticipation or something real clear like that, without sort of seeing how things are developing. And I think an auxiliary set of claims really helps you set it up to work that way. I got a question for you.
Okay.
So you mentioned early on that with the changes to oaths and declarations and being able to prosecute a patent in the name of a company, if you just want to keep doing things the way you were, do you have to do anything differently now? You have to change your forms? I mean, what do you have to do come the 16th of September?
Right. So if nothing else, you will have to change your declaration forms because oaths and declarations are still required under the rules. They can just be submitted at a later time. And if you're in the habit of filing oaths and declarations and seeking patent applications in the name of an inventor, then you can still do that. And the only thing you have to change is changing the actual document you submit that the inventors review and sign and then forward to the patent office. So other than that, you could continue to practice as you have normally, but change the document that you submit.
Okay, thank you.
And I'm not seeing any other questions, but if there are other questions, I know that we're willing to field questions, and you can review the materials that we'll present online after this seminar is concluded.
Well, thank you very much for joining us.
Thank you.
This concludes our presentation. Don't forget to download the speaker bios and the presentation before you tune out. We are delighted to answer additional questions afterwards by phone or email. And remember, you must respond to the check-in tracking to get CLE credit. Your certificate of attendance will be sent within 10 business days. Thanks to everyone for joining us.